Greetings everyone. The title of my paper is Defining the Legal Age Range of Childhood, Inconsistencies and its Repercussions. So let's say you aim to become a professor. So what is the foundation that you require? You need a good score in your law degree and in your UGC net and so on. And similarly for a lawyer, you need internship experience, mooting experience and so on. And what if you want to become a good human being? The foundation that you require is a happy and a healthy childhood. So what stops children from attaining a happy and a healthy childhood? It includes, but is not limited to, lack of education, which may lead to child labor, teenage pregnancy, which may lead to child marriage, drug addiction, which may lead to deviance and delinquency, and so on and so forth. So how do we address and handle these obstacles? Is firstly, we need to understand the world of children. So the most important attribute of a child is the tenderness of their age. Why is it important? Because they are physically immature and mentally naive. And age is what differentiates children from adults. So children's happiness and health may be provided to them by satisfying their needs and wants. So whose responsibility is it? It's mainly laid upon two parties, that is their parents and the state. So parents will have to satisfy their wants, and state should satisfy the basic needs such as education, clothing and shelter and so on and so forth. So what if the parents they don't have parents and they are orphans? Or what if they are incapacitated? Or what if the parents are incarcerated, they are put in the jail? Then it becomes the responsibility of the state to satisfy both the needs and wants of the children. So how do they do it? So the state satisfies the children's needs and wants by measures taken by the legislature and schemes by executives through positive discrimination. That is, when compared to adults. So children are provided differential treatment and special protection. So the challenges of state in fulfilling these responsibilities includes practical as well as constitutional challenges. Because state cannot identify each and every child's individual needs and wants and fix their problems. Because each child's needs and wants vary, and the pace and level of their growth also varies. And what are the constitutional challenges? So in Article 15, Clause 3, children shall be provided with special provisions along with women. But the problem is a subclassification of children cannot be made in order to provide special benefits and laws in the benefit of them, which may make the law unconstitutional. And one thing that people often fail to notice is that we have 5 grounds of discrimination in Article 15, including religion, race, caste, sex and place of birth. But we do not have age as a ground of discrimination. In the subclause 3, women who comes under the ground of sex are protected. But what about children? Even when the ground of age is not provided in the prohibition of discrimination, children have been included. This is not because of the popular belief that the constitutional makers were of a patriarchal mindset, that women and children always go together. No, that's not the actual reason. The reason is because in the patriarchy that is actually prevailing in our society, which makes both women and children vulnerable sections of our society. So what Article 15 talks about is negative discrimination, and specifically Article 13, Clause 3 talks about positive discrimination. So how do we provide protection to children? It is mainly based on the legal age range of childhood. Article 1 of the UNCRC defines who is a child. It defines stating that a child means every human being below the age of 18 years unless under the law applicable to the child majority is attained earlier. So what about the status in India? different laws have different definitions of who a child is. So in the UNCRC, it does not, in the convention of 1989, it is silent about the starting point of the age of childhood, because UNCRC being one of the most highly signed conventions, about 196 countries, let's say the starting point of childhood was actually debated, then matters such as abortion and family planning would have been debated, and this would have actually reduced the number of signatories. That's why the starting point of childhood has not been defined in the UNCRC. Whereas it was actually defined in the declaration in 1959 that the child needs legal protection before and as well as after birth. That is, it includes when the child is conceived in the womb of the mother. And what about the ending point of childhood? As per the convention, it states that 18th birthday, the childhood ends and majority is attained. So what the UNCRC committee encouraged is that states need to review the age of majority if it is set below 18 years, especially to raise the protection age of children, especially in matters such as marriage and child labor. So what are the issues in this aspect? For instance, in child education and labor, there is a contradiction. Article 21A of the Constitution provides compulsory education as a fundamental right between children of 6 and 14 years. Although the Child and Adolescent Labor Prohibition and Regulation Act of 1986, Section 3, it states that children can help in their family enterprise, which is other than hazardous occupation. And secondly, it allows children working in audiovisual entertainment industry, such as advertisements, films, and so on. So my suggestion would be to repeal the entire provision of helping in families' business, because the children can easily be convinced and consent can be easily acquired from the family members in working in the business, which would ultimately affect their education. And minimum age of labor should be increased uniformly to 18. And with regards to work as an artist in entertainment industry, so this cannot be entirely curtailed, because this is something which is based on the skill of the child, which needs development right from their childhood. So a consent of the child must be confirmed by obtaining a certification from a state authorized clinical psychologist that the child really consents to perform as an artist without the coercion by the parents or guardian. And with regards to age of marriage, Article 2 of the UNCRC states that children should not be discriminated against when the rights under UNCRC are realized. And UNCRC committee has repeatedly emphasized that states should fix an equal age of marriage for both girls and boys to comply with Article 2. Whereas in Indian law, Prohibition of Child Marriage Act 2006, the age of marriage for women, for male and female, are different. This reiterates the patriarchal belief that wife should be younger than the husband. And in Hindu Marriage Act, the marriage contracted by a bride of less than 18 years or a bridegroom less than 21 years would not be a void marriage, but only a voidable one, which would remain valid if no steps were taken to declare that the marriage was void when the bride attains the age of 18. And IPC exception 2 is violative of Article 14, 15 and 21 because it permits intrusive sexual intercourse with a girl child aged between 15 and 18 years only on the ground that she is married. And the POCSO provision is again contradicting with the other laws. It states that sexual activity with a minor is completely illegal. So my suggestion is that the legislature should bring legal clarity by providing necessary amendments with regards to rape, sexual consent and marriage. And also there's a bill to increase the minimum age of women, minimum age of marriage for women to 21. This move has been criticized because voting and driving rights are attained at the age of 18. But why not marriage? Because marriage affects life of only those individuals involved, but voting decides the fate of the nation. So my suggestion would be that instead of increasing the age of marriage of women, men's age of marriage must be reduced to 18 years. And as I already told, sexual consent. Sexual abuse, it does not only involve coercion or violence in the sexual activity, but even when the child has not attained a certain age, even if it is consensual, it is to be declared illegal. So that is what the UNCRC committee also suggests. In Vijayalakshmi versus State in 2021, I'm sorry. The Madras High Court directed that the age of the consent in sexual intercourse be reconsidered, lowering it from 18 to 16 years. Because the court observed that punishing a minor boy who enters into a relationship with a minor girl was never the objective of the POCSO Act. And finally, while making these amendments, two concepts have to be balanced. And this should be kept in the minds of the legislator while making these amendments. One is that the concept of child as a subject of rights whose evolving capacities must be respected. And secondly, the concept of state's obligation to provide special protection. And what do we mean by evolving capacities? It is the concept of child as a subject of rights whose evolving capacities of the child or youth to exercise rights on their own behalf rather than always turning towards the parents. And that's all for today. Thank you for the opportunity.